examine the entrance of the performance process specific
Experience. You are right. You are right. We capture the things in our mind first, then we'll translate it on the. Let us begin. Let's start.
Council stands before this Honorable Court of Jhansapura on behalf of petitioners, which is the environmental activists in the case of Environmental Activists versus Union of India. Starting with the facts of the case, the background deals with three most important facets. The first one dealing with the with the country concerned, which is Indrika. Second, the initiative of the union government in conflict. Third, with the Jhansapura, a state which is a particular state concerned in this case. Moving ahead with EIC, Eastern Industrial Corridor. This is an initiative of union government where they have proposed an idea of development without considering the ecological outcomes of the place. And there are mere verbal commitments. Further, there is a wetland which is hampered, Chandrapura wetland in Akis. This is a renowned ecological significance as biodiversity hotspot, mainly because of three presents. The first one is the migratory birds, which are in danger. Second one is the diverse fish species. And the third one is the agricultural activity done because of that present. Moving ahead with issue number one. Issue number one talks about whether the establishment of industrial hub violates the constitutional mandates under Articles 48A and 51A(g) of Constitutions.
Yes.
I will be covering this issue under three folds. The first one is explaining what a legislative intent behind these articles are. The second one talking about environment should precede over economic benefit in case of conflict. The third one talks about that there is a nexus between 48A and 51AG. Starting with my first contention, subcontention, to understand what is the legislative intent of 48A and 51AG, the Council wants to bring forward Article 250, which clearly states that union government and state government can make laws when they are signing, when India as a country is signing any treaty. Under this, a Stockholm Declaration was signed in 1972, which brought many amendments for environmental protection. Under this, the most important are 48A, 51AG, and Environmental Protection Act. The legislative intent behind these statutes are that to protect the environment with regards to the issue at hand, which are migratory birds, fishes, and agricultural activities. There is a case of Mumbai Kamghar Sabha versus Abdul Bhai Fizul Bhai, where Supreme Court gave where there were two ideas proposed: the strict constructionist and the harmonious interpretation. Indraka follows harmonious interpretation as it states that this doctrine states whenever there are ambiguous and conflict within the laws, it is the duty of the government judiciary to ensure that different parts of legal framework should together cohabit. Continuing with 48A, it is mentioned in the statute that protection and improvement of environment and safeguarding of forests and wildlife. It explicitly states that it should protect and improve the forest and wildlife of the country. 48A is not a mere aspiration. Instead, it should actively guide the state's decision in making matters concerning industrial expansion.
It is in which chapter of the Constitution? This article?
Four.
Hmm? Yeah. What is the title of that chapter?
It is read as fundamental duties. Moving ahead with the contention about precautionary principle. It is submitted before the Honorable Court that there is a precautionary principle which was brought in the case of AP Pollution Board, which clearly states that instead of making something happen, it is better to take a precautionary steps and understand what are the damages which may occur because of the establishment which they are doing. It is submitted that there is an irreversible ecological damage waiting for the harm to occur, contradicts sustainable development and intergenerational equity. And this burden lies on the respondents to prove no harm, necessitating EIAs, alternative site considerations, and strict safeguard to fulfill obligations. Moving ahead with 51.
No, yes, all right, yes, continue, 51 AG.
Moving ahead with 51 AG is the matter concerned here is the duties which the citizens have and the state also have in revolts.
Is it in the same chapter, chapter 4, you said?
Yes, Your Lordship.
It is in 4A of the Constitution.
What it reads, the title of that chapter?
Fundamental duties. It is an amendment which is brought in 4, chapter 4. It is most humbly submitted that the coexistence of rights and duties is a fundamental principle of constitutional law. It is submitted before this honorable court that there is a public trust doctrine that we as the citizen of the country of Indrika have given responsibility and government have some responsibilities towards the citizens. In our case, these responsibilities are on natural resources. First, the wetlands, forest, water bodies, which are held in trust by the state for public use and it cannot be transferred for commercial exploitation. Undermining these activities of the government, which is failure to uphold environmental protections, undermine the very foundation of a responsible government. Concluding my first subcontention, the government cannot act as both the violator and, the protector of environmental rights. Coming to my second subcontention, which clearly states that in conflict between environment and economy, environment should be given a priority. Starting with the contention that part 4 of the Constitution has regarded as socio-economic Magna Carta. The sustainable development cannot come at the cost of irreversible ecological damage. It is also mentioned in under Section 3 of Environment Protection Act. Then under this section, there are some mandates which are given to the for any of the developing party if they are doing a certain construction and if there is an ecological damage which may be in future brought in that area, they have to comply with Section 3 and if only they comply with Section 3, they can move
So
on.
read section 3, what is you would like to read?
Section 3 is read as power of central government to take measures to protect and improve environment. Under this, 10 guidelines are given. The first one, coordination of actions of state
No,
government.
no, what the section reads?
Section is read as power of central government to take measures
Yes.
to protect and improve the environment.
Yes.
So whenever there is any
Nothing beyond that, means that is the head note which you are reading according to us. But what is the section, what it says?
section
Read
provides
the
the guidelines that whenever there is any development which has to be brought in a certain area which is hampering or may hamper the ecological balance of that place, then these 10 mandates have to be followed. They also give rise to EIA, which is Impact Assessment Committee, and that committee, after going through all those mandates, then only a construction has to be brought in that. In our case, government has not come mandates which are provided under Section 3. Moving to the next contention, it is submitted that World Commission on Environment states that today conservation But how to the most important part. Concluding my sub-contention, it is most humbly submitted that wetlands serve as a critical breeding and nesting grounds for migratory birds, aquatic ensuring biodiversity. This appearance of even one single species would disrupt the entire food chain, causing cascading effects of the ecosystem. Moving to the last sub-contention,
Yes.
which was there is a synergistic nexus between 48A and 51A G of the Constitution. It is most humbly submitted that when Article 48A mandates state to safeguard forest, lake, rivers, and wildlife, similarly 51AG extends its duty to the citizens to protect the natural environment and show compassion for living creatures. And together, both the articles emphasize that development, conservation, and animal welfare are constitutional mandates requiring both state action and citizen responsibility. Concluding my argument, it is most humbly submitted that there is a convention, Ramsar Convention, and India is a party to it. India has a legal obligation to ensure that wetlands designated
Is Indrika a signatory to that?
indeed, Your Lordship.
All right.
And because it is a signatory, India has a legal obligation to ensure that wetlands designated under this framework are not disregarded due to unsustainable development. That's all from my side. My co-counsel will be dealing with issue number 2 and 3.
All right. Yes.
Council seeks permission to begin with
Yes,
issue number 2.
Yeah.
So the issue number 2 reads as whether balancing socio-economic development with the environmental protection creates constitutional tension. So council will begin with explaining as to what are constitutional tensions.
Yes.
Constitutional tension basically refers to the conflicts or the challenges which occur when distinct constitutional principles, rights or obligations appear to be in conflict with each other. Now, when these appear, it must be struck down that there should be no competing interest basically. Now, how to examine these competing interests? So, the petitioners have found out three debatable questions. Now, those three debatable questions are right to healthy environment versus development interest, which invokes Article 21, in economic growth versus ecological growth, which invokes Article 19(1)(g), needs of present generation versus needs of future generation, which will bring Article 14 into the picture. So the council will one by one be dealing with its violations.
Yes.
Council seeks. So before moving forward, council would also like to bring it to the notice of the court that all these articles also form the golden triangle, which came in the case of Maneka Gandhi versus Union of India, and it was reinforced in Kharak Singh versus State of UP and R.C. Cooper versus Union of India. Council would like to prove through its argument that not only this case Article 21 is violated, but also there's no valid reason to violate Article 14 and 19, and that is why it is also weakening the legislative intent behind the same. Council would now like to begin with Article 21, which comes through the debate of right to healthy environment versus developmental interest. Now, the petitioner would first like to begin with establishing a proven fact that through various precedents, as in the case of Animal Welfare Board of India and versus A. Nagaraja and T. N. Godavarman versus Union of India, that Article 21 includes not only animals, not only human beings, but also rights of animals, forests, wildlife, and natural resources. Now, to dwell specifically into the matters of endangered species, as in our case, there's an involvement of endangered species. There's a case for them also, like the Center for Environment Law (WWF) versus Union of India, in which it was held that endangered species have the right to live on this earth, just like.
Which are those endangered species in this case?
Your Lordship, we have mentioned it in the contention number 2.2.6.2, along with the scientific names, like what are the species in the Chandrapura wetland present at this point. After this, I'll also be covering the contention of color codes. I will move to that only. So there are basically 4 color codes. The red color code, the orange, yellow, and blue. Critically endangered, vulnerable, and nearly threatened. So in the Chandrapura wetlands, we can see the existence of all these 4 species, which we have mentioned in our contention 2.2.6.2, Your Lordship.
They are endangered because of what presently?
We believe it's the environment itself that is degrading the quality of the water.
As of today, what is endangered? How they are endangered?
They're
As
endangered
of today,
as of today because they have
what
lessened
are
in
the
number.
facts which lead to their endangerment?
They have lessened in number because of lack of, we believe, lack of water, and this itself, the environment pollution that may be caused.
Yes.
I would now be dealing with this issue itself. There are color codes, and it is mentioned that all these four are present. So it is actually important to delve into this matter because they are critically endangered at this point, and there's a near probability that they will soon become extinct. So I would also like to deal with the case of Consumer Education and Research Center versus Union of India and MC Mehta, where it was stated that right to life extends beyond mere existence and which should be kept in mind in this case. In the case of Amarnath Shrine Re, also the court reaffirmed that right to clean and healthy environment is the fundamental to right to life, and in this activity also we need to keep that in mind. Now, I would be dealing with a holistic approach of this. So, the council would like to bring into the attention the court that there's a difference between environment protection and ecology. So, what we are contending here is not the problem with the environmental issues itself. It is the ecology which is being hampered as a whole. Now, the ecology will not only affect the human beings.
What is the difference between that? You said? Ecology.
Environment will contain the biotic and the abiotic components.
Yes.
Now that will we will only consider the effect of that. Whereas ecological cycle will contain all of it, like the biodiversity, the food chain, the natural equilibrium will come into picture. It's a whole process that will come into picture when we are actually talking about ecology. But environment will only focus on the two things: the abiotic, the living, and the non-living.
Correct.
In the case of Indian Council for Enviro-Legal Action versus Union of India, recognized the far-reaching consequences of ecological damage as well, and MC Mehta versus Union of India, courts recognize it to be the state's duty to prevent the ecological harm. So ecology is basically a very complex concept, but if we actually need to delve into sustainable development, we need to look from a bigger point of view, that is ecology and not only environment protection. Um, in the case stated in T.N. Godavaran versus Union of India, it was held that the forest biodiversity and the ecosystem must be preserved not only for environment protection but also as a part of ecological system that supports life itself. As per my contention for 21, I would like to conclude that there is a violation of right Article 21 in this case. Now I would like to
Now,
move
in what
forward.
way? Article 21, how it is violated in this case?
Your Lordship, because our first contention is that it not only involves the human beings, but as through certain precedents we've laid down, it also says that it also includes other species as well, like the fishes.
No, no, but Article 21 speaks about what?
Right to life, Your Lordship.
Yes, but what? How it is worded? We would like to know more about that article.
It is because there's a cycle. It also includes the species. Now they are endangered. They are on the verge of extinction. If they will be extinct, that will definitely be a clear violation of Article 21, Your Lordship.
How? What does it say?
By taking life, Your Lordship, it will actually hamper them by taking their life. So if they are also included within the ambit of Article 21, we also need to look for their well-being.
What are the facts which are life-threatening there?
Life-threatening, there is
Which
a
will
setting.
ultimately.
Yes, Your Lordship, I
Yes.
understand now. So basically, there's an industry that they have planned to set up. Now the industry basically works with the works of manufacturing and all. So there will be effluents that will be passed. There will be discharges that will be directly passed into the wetlands that are there. So that would directly affect the fishes that are present there. Then the migratory birds that come there. So that's how this
But
connection.
what material you have got to show to what extent they will be affected? You have some reports of some in support of your contention.
What extent, Your Lordship?
Because as you say, balancing is necessary, that you agree. So how do you say that the balance is tilting that side?
Your
You
Lordship,
place the facts. What are the facts
I
which will
understood the question.
translate into such a threat that it will completely ultimately
Basically, Your Lordship.
extinguish the life there, which
Yes,
is
Your
now presently existing.
Your Lordship,
The
as
article life is of human beings, that life. You can't jump to that way unless it affects the human beings.
It
Article
does affect
21,
the,
as we understand,
we are contending that only. It does affect the human being. That's why we brought into picture. Yes. That's why we brought into the picture the concept of environment and ecological cycle. Ecological cycle not only involves human beings but also all these species. So even the extinction of this one species will disbalance the whole ecological cycle. And as for your question, we agree that we do not agree because there were certain requirements that they needed to follow, and they haven't. Like as per section 3 and 5, this EIA in.
anyway, yes, you continue.
Yes, Your Lordship, that is my contention. That for environment, Your Lordship.
So they have not complied with the procedural requirements which are mandated. Is that your case?
Your Lordship, we believe that they couldn't be doing that. That is what the reason they haven't done that, because we still believe that there will be discharges, there will be a large amount of impact that will be put on the
But the
industry.
other council
because
said
of
that there are, or you only said that there are 10 guidelines. No, there are 10 guidelines when the government has to approve some proposal or go about development. So, are these guidelines followed or not followed, or they are not likely to be followed? What is your case?
Our case is that these guidelines are not followed because they are not likely to be followed. As of now, they are not followed. There was a time, as per Environment Assessment Act, there was a time period according to which they have to be completed. But because they have not done that, we believe that there are reasons they have not done that, because they couldn't be doing that, because creating an industry will definitely hamper the environment, because when once we'll create an industry, there will be expansion. So we still believe that this wetland, also as my co-counsel stated, that it is a Ramsar protected site. And this wetland itself, as we have identified, is one amongst the Ramsar Convention that is protected. 75 around are protected under Ramsar, and this is also one of them. So for especially Ramsar protected site, we have to look for special measures. And also, yes, Your Lordship, if I may continue.
Yes.
Your Lordship, through the violation of Article 14, I will be dealing with mainly two aspects, in which I'll also be covering one of the questions that you asked before, is the principles of non-arbitrariness and the rule of law. So, dwelling directly into how there's no arbitrariness in this case. Arbitrariness, because EIA also, we have given the compendium where there are guidelines as per EIA that there should be public consultation. Now, they haven't done the public consultation. Now, if the public at large here is being affected, they have to have done the public consultation at least before starting this project, or this is a union project which is signed by several states.
No, but what is the stage of the project? It has what is the stage means commenced? It is not yet commenced. No? Is there any guideline at what stage they have to consult? This public consultation is to be done at what stage? Is there any guideline or time frame for that?
There's 60 days by which you have to do the EIA, and EIA involves public consultation, Your Lordship.
The EIA has been done or not done?
No, EIA hasn't been done. That is my. They haven't involved public, and now since public is the, because this is a union project, and as per the fact sheet, I believe, Your Lordship, state of Jhansapura has already signed to be a part to actually go forward with the project. Uh, so so since they are also a party to it, it is not. State of Jhansapura is definitely a matter of concern, and all the people of state of Jhansapura also should be brought into the loop while giving any or passing signing to any of such contracts.
Yes.
Your Lordship, now I will be dealing with article in the same thing. In the same article, violation of Article 14, I will also be dealing with the concept of intergenerational equity. So the principle of intergenerational equity mandates the state's fiduciary relationship to preserve the natural resources for future generations. In the state of Kinkari Devi versus state of UP, it was held that indiscriminate mining without environment safeguard violates Article 14, and as it is arbitrary, it deprives certain communities of certain environmental resources, which includes the future sustainability aspect as well. Then, in the state of Meghalaya versus Al Demasa Student Union, the Supreme Court affirmed that natural resources are not meant only to be consumed, are not meant only to be consumed by the present generation but also by the future generation. Because of time of constraint of time, the I would mention the cases also,
Yes.
other cases in which
Just
it was
mention
mentioned.
briefly.
Yes, your lordship,
Yes.
the contention from contention 2.2.3, 2.3.3.5, the cases are mentioned. Your lordship, concluding this point, there's a very, I believe there's a very selective approach that they have followed. The respondent council have given the violation of article 21, and I believe that there is also other articles that needs to be kept in mind, non-violation, sorry. Also, I believe I will be covering the last issue, Article 19(1)(g). Because of constraint of time, I will only mention one case, that is Rajkot Dyeing and Printing Industries. In this case, there were similar facts, and 30,000 people were getting employment in this case also. But uh, there were great environmental effects that were present there. So they chose environment over the economic aspect in this case. If your lordships are satisfied with this issue, I would also like to move to next issue.
Yes, please go ahead.
Yes, your lordship, much obliged. Council will now be dealing with issue number 3, which is whether sustainable development principles can be enforced through judicial review. So first, I'll be dealing with the intent of the judicial review. Then I'll be dealing the paramount significance of relationship between a PIL and judicial review. Then I'll give the backing of sustainable development by well-established legislative framework of India. Council starts with the first contention, that is legislative intent of judicial review. The main purpose of judicial review is to serve as a mechanism for ensuring the checks and balances for both the legislative as well as the executive. It is pertinent to note that the executive actions pertaining to any violation of the duty imposed on it fall within the purview of judicial review and are subject to direct and unquestionable enforcement. Petitioner also argued that unchecked industrial expansion, such as the one in our case, the Chandrapura Industrial Hub, transgresses constitutional boundaries as proved in the prior issue, that is issue number 2, and raises questions of checking the activities of executive in this case. Similarly, in the case of SS Bola, court reaffirmed that judicial review serves as a safeguard against arbitrary actions of both legislative and the executive. Basically, judicial intervention in such environmental matters is relating to sustainable development principle is not an overreach but a constitutional duty. As in this case, it is the duty of the court to actually intervene in this case and look over it. I would like to move forward to my second contention of the same issue, that is paramount significance of relationship between the PIL and judicial review. So judicial review.
Yes.
Yes,
Finish
Your
within 2 minutes.
I will finish it, Your Lordship. So, in the present case, the Council would establish a nexus between PIL and judicial review for the preservation of constitutional tenets and attainment of equitable outcome. PIL functions as an extension of judicial review, facilitating enforcement of fundamental rights and statutory provisions in the matters of pervasive public concern. In contradiction to the traditional view that was followed, PIL also relaxes the locus standi as given in contention
So
5.
now, according to you, locus standi is not relevant at all.
Your lordship, relaxing locus standi in the sense that, as in our case, the state is not upholding its duty. Now, any group of people can come forward for that. So it is not completely like there needs to be a vulnerable section of the society that needs to come forward in order to file a PIL. So we are contending that only in our case.
So according to that rule, old rule is relaxed now. Locus standi is widened.
Locus standi is widened in the case of PIL, Your Lordship, because the old traditional view is that only the people who are actually aggrieved can come forward with that. But bringing introduction of PIL relaxes the rule of locus standi.
But when that can be relaxed when? Under what circumstances? Not in all cases, obviously. You don't mean to say that in all cases.
When there's a matter of society actually concerned, there are certain situations like in the matter of habeas corpus, the PIL is
Habeas
that
corpus,
is,
locus
habeas
standi,
corpus
yes.
also the locus standi is concerned. Similarly, in PIL also, when there's actual aggrieved party section of society at a large which is actually aggrieved at that point.
If they are aggrieved, then there is no question of relaxing locus standi, because then locus standi exists if they are aggrieved. when you speak of diluting the rule of locus standi, it means that though strictly they are not affected, still they can move the court.
Yes, Your Lordship, because some are as of now, talking specifically about our case, yes, as of now, there might not be any effect to them. But once it actually comes into the picture, the establishment of this industrial hub, they will definitely get hampered by that.
All right.
Yes, Your Lordship, as my time has been
Yes.
over, I would, in 30 seconds, sum up that there's also a legal backing of sustainable development with a very well established legislative framework of India. As also stated by my co-counsel, after the 42nd Amendment, these articles were brought forward for the environment. After the ratification of the Stockholm Declaration, then there was 42nd Amendment, and only then these articles came into picture. So today we also have the Environment Protection Act, the Act for Biodiversity, for water, for air, for each and everything we have these, and it is incorporated through various precedents as well as these statutes. That there's a well-established framework in India and can be incorporated by its means.
All right.
Much obliged. I would like to make also my prayer. Your Lordship.
So this now only that part is remaining. Your time is over already.
Yes, Your Lordship, in light of the facts of the case, issues raised, arguments advanced, and authorities cited, the Council on behalf of petitioner humbly pray before the Honorable High Court of Jhansi to kindly adjudge and declare that the expansion of industrial hub near the wetland through EIC is violative of constitutional environment protection mandates under Article 48A and 51 AG, and therefore should be struck down. That there's a need to balance the socio-economic development with the environment protection, which could only be brought about by the non-violation of the Golden Triangle. That substantial development plans can be enforced through judicial review, and hence most humbly requested to the Honorable Court to take necessary steps for the protection of environment and endangered migratory birds along with the fishes.
All right.
Much obliged.
Yes.
Just 1 minute. Just 1 minute.
Now they have to argue. They have to argue. They can teach with
Yes, yes. These respondents can come in.
Greetings to this honorable bench. I would be appearing as counsel one on behalf of the respondents. If I may address this judgment collectively during the course of this proceedings.
Yes.
Much obliged, Your Lordships. Your Lordships are well versed with the facts of this case. I wish to proceed with the issues for consideration. Issue 1. Whether the establishment of the industrial hub violates the constitutional environmental protection mandates under Article 48A and 51 AG. Your Lordships, if I may take your kind reference to the memorial, page 13.1. Page 13.1. It talks about, it is here that the respondents state that the PIL so filed be held non-maintainable. The reason for this being is that, Your Lordships, there is already an alternate remedy so provided. If Your Lordships can look at,
what is that alternate
yes, Your
remedy?
Lordships, submission 1 of the compendium.
Yes.
Submission 1 of the compendium, page 6, chapter 3. Submission 1 deals with the NGT Act of 2010. It talks about
Yes.
the tribunal shall have the jurisdiction over all civil cases where a substantial question relating to environment is involved and such a question arises out of the implementation of the enactment specified under Schedule 1.
No, which part of the pleadings you are referring to?
Chapter 3, Your Lordship, page 6 of the NGT for submission.
Chapter 3.
Yes.
Yeah. Page 6, no?
Page 6, point 14. The tribunal shall have the jurisdiction over all civil cases where a substantial question relating to the environment is involved and such a question arises out of the implementation of the enactment specified in Schedule 1. Now, if Your Lordship,
We are not
Where your page 6?
compendium, Your Lordship, compendium. No,
Page
that's the
6.
memorial, the compendium. The compendium has been submitted. The first submission, NGT Act, page 6.
Twice.
Yes.
May I read it out?
Yes.
Chapter 3.14, page 6. The tribunal shall have the jurisdiction over all civil cases where a substantial question relating to the environment is involved and such a question arises out of the implementation of the enactment so specified under Schedule 1. Now, if your lordships may look at page 15 of the same submission that talks about Schedule 1 per se. Over here, point 5 is the Environment Protection Act. Now, if my learned friends say that there are violations of the Environment Protection Act, then the first remedy should be the NGT, not this Honorable High Court. Your Lordships, in tandem with that, if your Lordships now look at the Memorial, point 2, Memorial point 2, page 13, it talks about in Praveen Kumar Pradhan versus the National Green Tribunal, the exceptions to the rule of alternate remedy were outlined, allowing writ petitions under Article 226 in specific cases only. Point 1, when fundamental rights are violated. Point 2, when principles of natural justice are breached. And point 3, when the impugned proceedings are ultra vires, stating that the rule excluding the writ jurisdiction on the grounds of an alternate remedy is a rule of discretion and not of locus standi or location. So here, your lordship, the required sites are point 1, if there is an infringement to any fundamental rights. Now, the respondents so humbly maintain that the establishment has not even started. There has just been a place that has been earmarked as per the proposition. So, what violation and of what fundamental rights are we talking about here? That's submission number 1. Your lordships, if I may take your lordships now to the history of Article 48A and 51 AG. Your lordships, if we look at Article 48A and 51 AG, it came via the 42nd Amendment Act that happened in 1976. Just a few years prior to that, we had the Stockholm Declaration in 1972. There were 152 signatories. And if we look at the crux of the Stockholm Declaration, that is, if I may read it out, your lordships,
Yes.
point 4. In the developing countries, most of the environmental problems are caused by underdevelopment. Millions continue to live far below the minimum levels required for a decent human existence, deprived of adequate food and clothing, shelter and education, health and sanitation. Your lordship, it is here that the state rather tries to step in to protect the life and livelihood of these people. Your lordships, in regards to this, I would also like to put forth that there has been no infringement of Article 21A. If I may take your lordship's kind attention to page 15 of the memorial, the enforcement of Article 48A, page 15, point 15 and 16. Memorial, page 15, point 15 and 16. If I may proceed?
Yes. Yes.
Yes, your lordships. The
Page?
text of Article 48A here says,
Uh,
50.
50.
Yes, sir.
the text of Article 48A, and I am quoting it from the bare act of the Constitution, protection and improvement of the environment and safeguarding of forest and wildlife. The state shall endeavor to protect and improve. There are two parts over here: to protect and improve the environment and to safeguard the forest and wildlife of the country. The Lordship's point 16. Imperative to note herein is that the term improvement ties in with development, largely with the principles of sustainable development, which seeks to achieve development along with necessary protection of the environment. Your Lordship, even in reference to the same, if I may take your Lordship's kind attention to something that was quoted in Rajiv Suri in regards to sustainable development. Here, your Lordship, the respondents are again maintaining that we do not want to hamper the environment. So, whatever will be done with checks and balances. And we will put forth the same as we proceed. Rajiv Suri, your Lordships, the principle of sustainable development and precautionary principles need to be understood in a proper context. The expression sustainable development incorporates a wide meaning within its fold. It contemplates the development ought to be sustainable with the idea of preservation of natural environment. It would not be without significance to note that sustainable development is indeed a principle of development. It possesses controlled development. And here, your lordships, I would like to put forth submissions in the compendium 4, 5, 6, and 7. The compendium 4, 5, 6, and 7. The red folder. 4 talks about a national wetland committee constituted.
Yes.
Page number.
The compendium.
Office memorandum. You're reading?
Submission 4 is marked over there. 4, 5. The compendium, submission 4, 5. If one of us, please help your lordship.
Sure. 4, 5, and 6. Yes.
Yes. Yes.
Yes, your lordships. Submission 4, annexure 4 talks about the constitution of a national wetlands committee. So the respondents herein put forth that there is a national wetlands committee constituted. If you look at 5, it also talks about the composition of this committee. What would be the composition of this committee?
Yes, yes.
Perhaps 6 talks about the guidelines there for wetlands. And 7, your lordships, the most important, a pre-feasibility report. Now, my learned friends had even put forth claims that the EIA was done, but there was no public consultation. Here, your lordships, I would like to humbly submit that in the EIA notification rules of 2010, section 7, it talks about 4 stages. Screening, scoping, third one is public consultation. But that's a part of the EIA. Before the EIA, we had the pre-feasibility test done, and that has been submitted. The respondents even
That has
maintained
been done.
that has been done, it has been submitted. And the respondents even maintained that for the next stage, that would be the EIA, we would have public consultation. Then why this petition here and now?
You would be having public
Yes.
consultation.
Yes, we would be having it done as part of the EIA notification rules of 2010, in total adhering to the rules.
So accordingly, that stage has not yet arrived.
Yes, your lordship. Then
Very
I would,
good.
yes, and I would like to proceed further to tell you how and why. Yes, your lordship.
Yes. Proceed.
Your lordship, if you look at page 15, point 17 and 18, page 15, point 17 and 18
Your
of the memorial.
Memorandum.
Yes. Page 15, point 17, 18.
yes.
Yes. 17 talks about Goa Foundation case. Yes, your lordships?
Yes.
In the above mentioned case, point 18, the court held that the permission granted to the proposed hotel project was based on relevant material and after having given due regard to the coastal regulation zone notifications dated 19-2-1991 issued by the Ministry of Environment and Forest under section so and so. And then 20 and 21, we talk about the nature lovers movement, wherein that the government had put forth orders laying down conditions to regulate any exploitation of the environment and natural resources. However, it did not impose a total prohibition in that matter. This is an important point to maintain here. That it did check, the judiciary did check whether or not compliances have been adhered to, and once they found that compliances have been adhered to, they thought of letting it go ahead. That's one submission therein. Lordships, next, I would also like to move to the public trust doctrine. The respondents humbly maintain that the public trust doctrine, as it was stated in Kamal Nath, it has been adhered to. Here, the state is acting as a trustee of the resources of the environment. Your lordships, I would also like to take your kind attention to this particular point that was quoted in Kamal Nath. The doctrine enjoins upon the government to protect the resources for the enjoyment of the general public rather than to permit their use for private ownership. Here, private ownership has been set out as a bar. But here, the respondents maintain that this industrial hub could also help to boost the state of Jhansapura as of now. And a very important submission here, your lordship, is in the compendium, submission number 3. It talks about the current state of Jhansapura. Submission number 3, Jhansapura and industrial
You are
development.
referring where? Where to
The
which?
compendium, the big
Yeah.
bulk of pages.
You are referring to annexure?
3, annexure 3,
Yes.
Jhansapura and industrial development. Your lordship, page 1 of it, the last paragraph down, which has been highlighted. At the same time, it is also Jhansapura is also a state having considerable income inequality and low state domestic product. As can be seen, the state has been consistent in maintaining its per capita HDP significantly lower than all Indica GDP over the years since inception. Your Lordship, page 2, it even talks about Jhansapura being below poverty line. The second paragraph, so we find that the state has rich resources, yes, but poor production and slow growth of the HDP. The next paragraph, the statistics support this assumption. We see that Jhansapura really has a major population living below poverty line. It is here, your lordships, that primarily because of this reason, we want an industrial hub to be set up, but not at the cost of the environment. Because of which we have all these committees set up, the pre-feasibility report set up. Now the pre-feasibility report would also have a delineation done. So the delineation would deal with what kind of a wetland is Chandrapura, what industries would support it, how far would the toxic effluents be let out. All this would be kept in due consideration.
What about the safety of these endangered species, like they said? Have you studied
Yes, Your
that
Lordship.
particular, or it is in the process?
As of now, as I said, the pre-feasibility report will help us know what kind of species are there, what suits them, what does not suit them. And overall, if you see, your lordships, any wetland, if it's exhausted too much, the respondents are well aware, if it's exhausted too much, it can convert itself into a source of carbon dioxide, which the respondents do not want. Forget the endangered species, it would be toxic to the people of Jhansapura itself and the entire country of Indica as a whole, for which the respondents humbly submit that we are not ready for such a catastrophic happening, due to which we have this Dalan proceedings. And of course, the respondents yet maintain that due public consultation would be done to take in their reasoning, to take in their concerns, to know where do they want us to have it. Because again, the proposition quite clearly states that there are agricultural activities happening right now over there. Now, by virtue of that fact, agricultural activities would also mean some sort of livelihood. The state doesn't want to deprive them of their livelihood. Hence, now if I proceed to issue number 2, I would like to maintain how these two can be balanced, wherein BPSPs are balanced with fundamental
Yes.
rights there.
Yes,
Shall
better
we
go to
proceed?
issue number 2.
Yes, your lordships, much obliged. Your lordships, issue number 2, it starts in the memorial from page 18. Page 18. Your lordships, here it talks about whether the balancing of socio-economic development with environmental protection creates constitutional tensions.
Yes.
Here, your lordships, the respondents most humbly maintain that it does not inherently create any constitutional tensions. Allow me to explain how. Your lordships, it was in Champakam Durai Rajan 1951 that dealt with a DPSP, that is Article 46, promotion of education, economics, all of that, with Article 14, right to equality. Now, back then, the court had given precedence to a fundamental right over a BPSP. To a fundamental right over a DPSP. DPSP is under Part 4, fundamental rights under Part 3. But after that, we had Kesavananda Bharti in 1973. Then we had in 1980 the Minerva Mills. Wherein in Minerva Mills, as part of the basic structure doctrine, the balancing of directive principles along with fundamental rights has been considered as a basic structure of the Indian constitution, of the constitution of Indrika, rather. Your lordships, if I may also further take your attention to point 2 on page 18. Issue 2, point 2, page 18. In Bombay Environmental Action Group was a state of Maharashtra, it was held, environmental issues are relevant and deserve consideration, but the needs of the environment require to be balanced with the needs of the community at large and the needs of developing countries. If one finds, your lordships, I reiterate this point, if one finds that all the safeguards have been taken and followed properly, there is no need for the Honorable Judiciary to interfere. Then point 3. In the state of Himachal Pradesh versus Yogendra Mohan Sen Gupta, it was held. We have gone through the development plan. The development plan has been finalized after taking into consideration the reports of various expert committees and studies undertaken with regard to various aspects, including environmental and ecological aspects. Now, your lordships, how is Article 21 related to all of this? If we may dive in deeper into it a bit. Over here, your lordships, Article 21, it reads as, your lordships are away, but I would just
That's all right.
it reads as protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Your lordships are well versed that over the time we have
So
had.
their argument you have heard. No, their argument
Yeah,
is
yeah.
that
So,
you will deprive the life of these to the endangered species, which will deprive life of the citizens also. That is how Article
It is
21.
a part of the cycle.
I don't see a nexus between
Ecological balance is.
Yes, Your Lordship, I don't see a
No, that is
nexus.
their contention.
Correct,
You
yeah.
may address,
Correct.
reply to that.
You may
Then
point
now
out
in the
what are the
reverse.
safeguards which are
Do I have it
built
now
here.
or in the
Now, while arguing, you can,
Yes,
because you
Your
are on
Lordship,
that issue only.
correct. Your Lordship, firstly, as far as I can recall, even Article 19(1)(g) was mentioned, right? On the contrary, I would thank my learned friends for putting that into the minds of the respondents that by the establishment of the industrial hub, we are not just implementing 21 but also 19(1)(g). Because 19(1)(g) deals with occupation and the creation of the industrial hub, the very creation of it in the pre-feasibility report has mentioned that would require employment of workers. So we are boosting the right to life. Article 48A, when done, when implemented in this way, helps boost Article 21. And now your lordship tying in right to life with right to livelihood is what we are coming to. Now, if I may quote, this is from the commentary of
Yeah, finish in 2 minutes.
MP Jain. He says he ties in right to life with right to livelihood. He says the right to life guaranteed. This was in reference to Olga Tellis. Of course, that was a case that dealt with payment dwellers, but there was a mention of this. The right to life guaranteed by Article 21 includes the right to livelihood. The court held in Olga Tellis a case brought by payment dwellers, all of that. It emphasized upon the close relationship between life and livelihood. The court stated that which alone makes it possible to leave aside what makes life livable must be deemed to be an integral component. Thereby saying that right to livelihood would help us to live in the first place. Given the current state of Jhansapura, how do they expect to live without a proper standard condition of living, a proper quality of life with no development? So, Your Lordship, these are our submissions that the respondents are in complete adherence with environmental norms. Nothing has been violated so far. The establishment in the first place has not even started. An area has been earmarked. So there is no question of the violation of any fundamental rights thereupon. So this case we rather refer to the NGT for now. And if at all there are yet contentions, after the public consultation is done, it may again be, if at all, required.
All it is.
That's all, Your Honor. Much obliged.
Yes.
I, Counsel 2, on behalf of the respondents, would like to proceed with issue 3.
Yes.
Whether sustainable development principles can be enforced through judicial review. Your Lordships, the respondents humbly submit that while sustainable development principles may be enforced by judiciary through judicial review, the same should not cross the thin line of it reaching to judicial overreach. The same has been enshrined under the Constitution of India under Article 50. Article 50 talks about the separation of judiciary from the executive. The state shall take steps to separate the judiciary from the executive in the public services of
No,
the
that is
state.
only as far as composition of these two things are concerned. It has nothing to do with these functions. It doesn't talk of functions. Separate means in its composition. Means same person should not be doing judicial work as well as administrative work. It means that only. Anyway, you can proceed further.
Your Lordships, it was in Indira Gandhi versus Raj Narain. It was given on the page number 23 of the memorial. Point number 10. The Supreme Court went to the extent to even rightly invalidate a clause of Article 329A. This regards to the election of the Prime Minister. In this case, it was held that the separation of power is part of the basic structure doctrine. If your Lordship may refer to the submission, Annexure 12 in the compendium, Annexure 12, page 18. Page 18, second paragraph, 7th line. Sachidanand Pandey versus State of West Bengal. If the government is alive to the various considerations requiring thought and deliberation and has arrived at a conscious decision after taking them into account, it may not be for this court to interfere in the absence of malafide.
Just wait.
Which you are referring to?
I'm referring to annexure 12,
Yes.
page 18,
Page 18.
second paragraph,
Yes.
seventh line.
Yes. Read.
If the government is alive to the various considerations requiring thought and deliberation and has arrived at a conscious decision after taking them into account, it may not be for this court to interfere in the absence of malafide. The respondents have no malafide intentions. Your Lordship, by the virtue of the fact that there has been submissions by way of environmental check reports, pre-feasibility reports, guidelines issues, and the committee constituted, this establishes that there is no malafide intent on part of the government.
So if there are no mala-fides, it cannot be subjected to judicial review. Are you making out that proposition?
It can be reviewed by the judiciary.
Even if there is no, then there are no mala-fides.
Yes. Furthermore, if your Lordship may also refer to point 8 of the memorial, page number 22. In Prabir Kumar Pradhan versus National Green Tribunal, page
Yes.
22.8.
Yes.
There is no doubt that the power of judicial review as conferred on the High Court under Articles 226 and 227 of the Constitution is sacrosanct and remains
Yes.
unaffected despite an appeal being provided under Sections 22 of the NGT Act. The court, however, would be loath to interfere except in extremely exceptional cases. The law in this regard is well settled. Your Lordship, the respondents fail to understand that how is this case an exceptional case unless proven otherwise. Your Lordship, moving to the other judicial pronouncements, Your Lordship may refer to page 23. Point number 12. This was quoted in the judgment in the case of Directorate of Film Festivals and Others versus Gaurav Ashwin Jain. The judgment stated, the scope of judicial review of governmental policy is now well defined. Courts do not and cannot act as appellate authorities examining the correctness, suitability, and appropriateness of a policy. Nor are courts advisors to the executive on matters of policy which the executive is entitled to formulate. The scope of judicial review when examining a policy of the government is to check whether it violates the fundamental rights of the citizens or is opposed to the provisions of the Constitution or opposed to any statutory provision or is manifested arbitrarily. Respondents have not violated any of the fundamental rights by establishing this industrial hub.
Yes.
Moving on to the point 11 of the memorial, point number, sorry, my lord, the respondents maintain that there has been no arbitrariness done, no infringement caused, which has already been submitted to this court in the arguments that are preceded this argument, and my co-counsel one has already submitted on that. Now moving on, your lordships, to page number 24, it talks about the test of arbitrariness.
Yes.
Whether the establishment of this industrial hub is something that fails the test of arbitrariness. As your lordship are aware, it was Article 14 that primarily deals with this test of arbitrariness. First, your lordships are already aware what's the test of arbitrariness state. It states that in order for a law or enactment to be struck down, it must be established that there is some level of arbitrariness involved. However, in absence of any arbitrary decision, the test of arbitrariness is ruled out. It is here that the respondents maintain that the decision to establish the industrial hub is in total adherence with the test of arbitrariness if applied. Reference of the same test was given in E.P. Royappa versus State of Tamil Nadu. Your Lordship, please refer to point 21 of the memorial.
Yes.
Page number 24.21. In E.P. Royappa versus State of Tamil Nadu, it was held. In the first place, we must make it clear.
Yeah, finish within 2 minutes.
We must make it clear, despite a very strenuous argument to the contrary, that we are not called upon to investigate into acts of maladministration by the political government headed by the second respondent. It is not within our province to embark on a far-flung inquiry into acts of commission and omission charged against the second respondent in the administration of the affairs of Tamil Nadu. This is not the scope of the inquiry before us, and we must decline to enter upon any such inquiry. Your Lordship, now I may proceed to the prayers.
Yes.
In the light of the facts of the case, issues raised, and arguments advanced, that this Honorable High Court of Jhansapura may be pleased to adjudge and declare that the petition be quashed prima facie, as the same would result in wasting the time of this Honorable Court. That the establishment of the industrial hub in the state of Jhansapura is in enforcement of Article 21 and is not in violation of Articles 48A and Article 51AG. That the establishment of the industrial hub is not in violation of the basic structure doctrine and its principles thereof. That the industry being set up is not in violation of the directive principles of state policy under Part 4 of the Constitution of Indrika. That the petition on behalf of the petitioners be held frivolous and in complete denial to any developmental initiatives by the state which would constitute for the overall development of the state of Jhansapura. That the environmental reports submitted by the respondent therein be taken into consideration by this honorable court. Much obliged.
Yes. Yes, rebuttal. Yes. Now,
Yes,
who will-
yes.
Yeah.
Yes, Your Lordship. So, firstly, starting with the jurisdiction. So, the entities' decisions are not absolute in nature. They are subject to judicial review, as already stated by my opponent.
No, but NGT, you have not approached NGT, no? Their argument is that alternative remedy is available and therefore you can't come to the High Court. So reply to that. What is
Your
your...
Lordship, I do not believe that entity has the power to deal with the constitutional matters and especially fundamental rights. And we are saying that there's violation of fundamental rights in this case involved. And also, PIL doesn't have a mandate of actually exhausting all the remedies and then coming to the court.
Why? That is, you don't accept the principle that if alternative remedy are available, then ordinarily the jurisdiction under 226 will not be exercised unless it is an exceptional case, like
We do accept
it was
it,
read.
and we also
So what is
believe that
exceptional about this?
it's exceptional because the environment, the people at large are at question.
All right.
Also, Your Lordship, my learned co-counsel said that we will look into the species that are present. So we have already actually looked into that and mentioned what species are there. Contention 2.2.6.2, and they are endangered. They are critically endangered. So, what question answer do they have for that? Also, I believe we cannot go beyond the fact sheet that has been provided to us. And in the fact sheet, it has been mentioned. It has nowhere been mentioned that any procedural things have been actually taken care of.
It is not mentioned in the fact sheets.
No, Your Lordship, they said
But
that they will be.
it is also not mentioned that these are not taken.
Yes, Your Lordship.
That is also not mentioned.
It is mentioned that they will be doing that. So
But they have referred to pre-feasibility report. No? What about that?
I believe they have not provided any report as of now.
So,
They have referred to the pre-feasibility report that has been, some study has been carried out.
as per the fact sheet, what is there which is not included in the fact sheet and stated by the respondent?
that I've actually gone through the feasibility report because we believe that they have said that they will be adhering to those that they have recommended.
All right, yes.
Yes, Your Lordship. And one more thing, uh, the last contention is that the livelihood will only come into picture when there are actually people left to give livelihood to. As it is important to denote that today the life expectancy ratio of India has actually gone down to 68, which is very low at this point. So that has to be kept in mind. And because of these environmental degradations that are there, we believe that this expectancy today is at 68, which was much higher earlier. So that's my questions to them, and my co-counsel will also have some questions.
I will be submitting before Your Honor just one query that our learned opponents have mentioned about the SDGs which promote no poverty and zero hunger. But there are still other SDGs like SDG 13, 14, and 15, which clearly states about climate action, life below water, and life on land. So if they want to adhere to sustainable development goals, they should look into these goals as well when doing any development goal. That's all.
Yes, in 1 minute you can.
Yes, Your Lordship. Your Lordships, it's quite fascinating that my learned friends are more concerned about the ecology and the endangered species rather than life in regards to human beings. For instance, even on page 32, they have mentioned ecology extends beyond environmental concerns. So, no matter whether or not state of Jhansapura has people working, but we will protect the species there. Also, I want to rather be enlightened that does Article 21 only apply to endangered species? Does it have no provisions to human life at all? That is one of
The
the and
life is interdependent.
yes, Your
That's
Lordship. So endangered species is a part of it. Surely it is a part of it. But is it really
The
entirely?
argument is that if the life of this endangered species that comes to an end, then that will affect human life. Of course,
Your
unless
Lordship,
you touch it
yes,
with the human life, there is no
correct. I
meaning
would
in these
humbly,
arguments.
I would humbly respond to this that that's a far-fetched argument in itself, wherein you're touching upon and if you're stating this very well, but how do you substantiate that claim? Is what is our concern here. And also, Your Lordships, they have stated they have
No, only about that we would like to know.
because something
Because
was
they
mentioned,
said that the fact sheet doesn't contain something which is
and even over here, the fact sheet doesn't contain that migratory birds are endangered, but that has been mentioned.
yes.
Yeah, just stating.
All right. Okay.
Just one thing, if I can say,
Only in one or two
it is
sentences.
mentioned that it is endangered in the fact sheet firstly, and also what we have taken out, we have taken carry material of everything. Chandrapura, we have identified as Chilika Lake. That when we have to take parameteria, so we have identified its distinct features are similar to that of Chilika Lake. And as per that, we have mentioned all the species that are endangered there also, and fact sheet also mentioned that it's endangered.
I may read from the fact sheet, Lordship. They are home to various species of migratory birds, diverse fish populations, and serve as an essential water source for agricultural activities in the region. Have they mentioned endangered migratory birds? Is my only point here.
So, Lordship, yes,
That's all.
the 6 point
That's all right.
mentioned and
Thank you so much. Yes, you said no.
Yes.
You want to say anything? One sentence you can say. Yeah. Yes, so we'll announce our verdict.
ठीक है no problem.
We will have our deliberations in some other dais. Just ask them to
Things are okay. Yes. There is like the secret.
We'd like to retire to some place. We will deliberate between us. And, we can That's it. We will deliberate between ourselves and let you know our verdict.
बैनर पे लेके आएंगे।